Oh, you oh,
Stopberg's doing it.
oh, I thought it wasn't supposed to move. Okay. Well, I was just going to get this started, so why don't we? Okay, let's. So what we wanted to look at is what are some potential legal solutions to some of the issues that we knew would arise. So what we have a great panel today. Is this short story? Let me just introduce a couple of our panelists. First is Professor Tim Westmoreland, who you know is also affiliated faculty with the ONeill Institute, who's been spent many years working on Capitol Hill, many years teaching legislation here, and has been the leader of this project for us, and he's going to walk through some of these issues. I also want to introduce Jackie Scott, who is make sure I've got this right, Jackie, senior fellow with the Harrison Institute, as well as a scholar with the ONeill Institute. Jackie has been the manager of this Legal Solutions Project, which we've gotten funding foundation to pursue. So I'm going to leave it to the two of them to kick this off, and they're going to also introduce some of the students and the other fellows that are affiliated with the Harrison Institute that are working on this project. So we're going to walk through that. And then we're very fortunate that in this project we've had two excellent advisors, two distinguished visitors with the ONeill Institute, Jack Ebler and Sheila Burke. Jack is a former Assistant Secretary for Planning and Evaluation at HHS, has been very much involved in health policy issues for most of the last 20 years or more in Washington. Sheila is formerly Chief of Staff to Senator Bob Dole, affiliated with the government, and is also affiliated with us at the ONeill Institute. And we're just fortunate to have them as advisors throughout the project. And given the fact that we're the day after the election, we thought we would ask them to comment after the presentations about how they see this project and these kinds of issues emerging in what could be the legislative process next year looking at health reform. So anyway, that's going to be kind of a fun day. And then, as usual, once the we'll probably do the presentations through the first half of the colloquium, take a break, and then we'll open it up to questions first from the students and then from everybody else. So if that makes sense, I'm going to turn this over to you. And if Bob, if you got the camera working, then that's great. So I'm going to give this back to you.
I think I'll just put it.
Maybe
I can put it in here.
What's up to you?
There it is. Okay. Good afternoon, everyone. I'm Jackie Scott, and I am a member of the Harrison Institute for Public Law, where I serve as a senior fellow and adjunct professor, and also a part of the ONeill Institute, leading the legal issues, solutions of health reform. As John said, I want to take a moment to just briefly introduce, and you'll meet them a little bit later in their presentations, but I want to introduce two of the other staff members who've been working diligently on this project and three of the students that you will hear from presenting today. Sarah Hoveder is a staff attorney and an adjunct professor at the Law Center here at the Harrison Institute, and Sandy Hahn has joined us this year as a fellow, a teaching fellow, and also is an attorney. She's here with us for 2 years, and Sarah has been on the project since the very beginning of its inception. And then today you'll hear from three of our students who are covering three of the issues. You'll hear first from Marissa Hornsby, and then you'll hear from Melanie McLean, and then Luis Rodriguez. And so they're going to talk with you about three of the issues, which we'll highlight a little bit later, by telling you a brief history of how we came to this point. And then I'm going to turn it over to Tim, who's going to talk to you a little bit about each of the 10 issues, or 9 issues, as you hear me sort of define. And then we'll talk in depth about the three that we've chosen to highlight today, talk a little bit about why we chose those 3 issues. The project began back in January of this year as an impetus of John Monahan, and in collaboration with Sheila Burke and Jack Ebler and a series of other experts across the country who were taking an interest in really drilling down deeper into the discussions of what it would really take to make health reform work in this country. So as we started to look at it, we began to talk about the complexities of what it would take to make it work, but also in the multitude of discussions taking place in the states and at the federal level, we really wanted to figure out how do you discuss from a legal context issues of cost, availability, affordability of health coverage. What's the range and how do we approach it? There were numerous, as you can imagine, academics and nonprofits and other organizations who were doing great policy work on this issue. So we had to figure out sort of where were the gaps. And there tended to be, over and over again in the conversation, significant gaps around the complexities of the legal issues. How do we tackle those legal issues? And first, how do we even define what a legal issue in the scope of health reform is and what does it look like? And believe me, that took quite a while in our own internal discussions. So through the support of the Robert Wood Johnson Foundation, in the spring of this year, we were able to launch officially this project. And so the Legal Solutions in Health Reform was sort of birthed in the spring after a meeting or during a meeting in May of a nationally selected group of experts that we brought together to discuss this issue. We really wanted to focus on the goal of identifying the key legal questions most likely to arise in the context of incremental or comprehensive health reform, and to develop really a diverse set of solutions that could be applied to those issues. We began to we really began this project with the bold premise of, yes, it actually is possible to come up with legal solutions for some of these questions that people have sort of decided, well, is there a legal issue or not? Maybe not. It's too hard to deal with the legal piece. Let's just stay with the policy piece. And we came in with the presumption of, yes, we can really come up with legal solutions to tackle this stuff. We wanted to create legal solutions and a discussion around legal solutions in a way that the issues can be sort of devised in such a way that we would decrease the chances of those tough technical barriers propping up and becoming insurmountable in people's minds and then becoming roadblocks to federal reform. But to be effective in the conversation, we wanted to start it in an arena that was outside of the politics and the political and policy debates that were going on. So how did we do that? Well, we were very deliberate about it, and we tried first by framing the questions very. We wanted to ask specific questions, so we sought to differentiate this project from those policy projects that were out there, recognizing that the line between a legal issue and a policy issue is not always bright. It's often quite difficult to figure out. So we focused here on the existence of what we termed as clear permission, or in some instances, clear prohibition. And that became sort of the dividing line between the legal and the policy alternatives that were being discussed. Specifically, the question circulated around, can we do something? Can was the key issue, was the key word there, as opposed to should we be doing something? The can being the legal question, the should being the policy question. And so we approached the framework very deliberately that way. Does the Constitution ever say that we can do this? Under the current statutes or regulations, can we currently do this, whatever this termed to be? So in May, we produced a paper that I think many of you have seen. It's posted on courseware, and it's also been disseminated widely. If there's anyone here who has not been able to get a copy or does not have a copy, we can make sure that you get one. And it was the paper that sort of framed a number of issues for discussion. And so we reflected back and we convened a diverse group of national experts, I think a couple of who have joined us in the room who were at that May meeting. And they were views from academia, the private sector, the public sector, the executive department, congressional staff, very broad group of people, and we presented this document to them. And I think, you know, to most of our both surprise and pleasure, many agreed that we had a good set. We had the right set of issues. And so the initial paper explored the following issues: privacy and security, ERISA, insurance exchanges, the definition of health insurance, the purchase of insurance across state lines, individual tax credits for health, preemption and federalism, insurance discrimination on the basis of health, and executive authority. When we convened this group of people, we asked them two specific questions as they reviewed the document. The first question was, do the issues in the document rise to the level of consideration as really being a key legal issue in the wake of any type of health reform? And the second question focused on, in light of the current debates or the likely future debates, are the issues really captured and framed correctly? So during that meeting, we got very specific feedback on each of the 10 issues. As I said earlier, we were surprised that really we thought we had it. We got a good set of feedback, and we were able to move forward. For the most part, all agreed that that's important and they were worth considering and moving forward on. So in that note, it's important also to recognize that we never approached the project with a focus of building consensus. That wasn't the focus. The focus was not to get people to agree around any particular issue or to agree on the veracity of any particular solution that might come from a particular issue. So that was not a barrier for us. It actually was a freeing piece of this project because we really were interested in tackling the tough issues from a broad perspective and a very comprehensive and inclusive perspective. So there was one caveat to that in the outcome of the meeting. You will notice as we discuss the projects that we're now down to 9 concrete issues. So now it's not really the top 10, it's top 9 plus 1 perhaps. So as a result of the advice from our group of experts, we decided to take out the preemption and federalism paper as one that would stand by itself and incorporate those issues as they cut across the other 9. And then create an overarching introductory piece that would not only hit on issues of preemption and federalism, but also discuss topics including jurisdiction, things related to jurisdiction, matters of enforcement, and remedies. So we will have 10 papers, but the first will be a cross-cutting introductory piece that will talk about how those issues arise in health reform. You will see that there's a handout, a blue handout that's been circulated that tells you who each of our lead authors are, who's writing which paper, and we wanted to make sure you had that so that in the future come out, and then we know that some of you are very familiar with those people, and so you'll have a sense of who our authors are and who's serving as experts on the project. So where are we at this point? All of our authors have made their way through a solid first draft of each of their issue papers. We have then been able to circulate those papers to advisory groups. We were lucky enough in this project to really be able to reach out across lines and get people to serve on each of the issue groups as advisors. So you have a lead author writing the paper. You have a small group of users who are now taking the paper, commenting on the papers, and providing feedback, which will then be embraced in the second and then final third drafts of those issue papers. We also, as an internal team, are working to provide the same kind of substantive feedback, and our students in the clinical work are providing the research and legal to those assistance to those. So finally, our time frame. We are hoping to have each of the issue papers done and in-house by December 1, and then ready for by December 15th. They will be available by way of hard copy and disseminated on the web. And then in January 09, we will launch an official sort of outreach strategy that will include an unveiling event to discuss all of the papers and to really talk with, an opportunity to talk with the authors and those involved. So there will be lots to stay tuned with, because throughout the spring we'll also be meeting with small groups of people to further get information on each of the topics. So at this point, I'm going to turn to Tim, and he's going to come up and talk to you about those issue briefs and a little bit provide some information on those, and then we'll make our rounds to the presentation.
I'm Tim Westmoreland, also from the Georgetown faculty, and I wanted to talk to you a little bit about each of the topics, but without being exhaustive about it, because we actually had a half-day meeting just to introduce the topics, and each of these papers is now at least 20 pages long, so if I tried to do it, we'd have to be here for 200 pages worth of discussion. But I thought I'd give an opening introduction to it so that when we get to the question and answer period, people can have an idea of what kinds of things we're trying to address. One of the things that I think is most crucial in discussing this, as Jackie said first, is trying to distinguish between the policy issues and the legal issues. And that the way we crafted this in the initial framing paper is not should we, which I consider a policy question, but can we, which is a legal question, and also the third question, which is how can we? And if we get to how can we, I think those are mixed questions of law and policy, and good drafting along the way. So we're trying to get to those questions of can we with possible solutions so that they don't become barricades. Oftentimes I think in the policy discussions when somebody raises a legal issue, it is immediately perceived as the barricade, we can go no further. And we're trying to discuss how can we, and with options for choosing to get around any barricades, and how can we, as a policy law issue, of what are the best methods to use. I would emphasize that we're not trying to come up with a consensus answer to this either, any more than we're trying to come up with a consensus about how to frame the question. In each of these memos, long papers, I would anticipate that we're going to have several possible answers. I don't want to go so far as to say liberal, conservative, and moderate, but we're going to have different ways of solving the questions that are raised. And the authors are committed to us to be discussing with the various reviewers, and they have industry and advocacy reviewers, they have congressional and agency reviewers, they have right, left, and center kind of reviewers. They've committed to us to try to get a variety of different answers so that if we're presenting to the Senate Finance Committee, we may not be giving the same answers if you're presenting to an Obama administration to choose which answer you want to do among the different choices. So with that idea, let me very quickly, in a thumbnail way, walk through the 9+1 topics and give you an idea of the kinds of things that we're discussing here. The first one, in my mind, the most fundamental one to start with is what is health insurance? What is the legal definition of health insurance? And in federal statutes alone, there are multiple current definitions of what constitutes health insurance, including some that are as vague as something issued by a health insurer. And so, you can look to the tax code, you can look to the ERISA statute, you can look to the Public Health Service Act, you can look to Medicare, Medicaid. You've got a wide variety of even federal definitions of what is health insurance. And then if you start going to state law, you have even more definitions of what constitutes health insurance. In all of these discussions, be they the McCain plan, be they the Obama plan, or the other major one that we discuss in this paper is the Wyden-Bennett proposal, we have to make some decisions about what we're mandating people to buy, or what we're subsidizing people to purchase, or what we're asking people to promise that they're going to provide. In order to do that, we have to have first decided, or at least attempted a decision, or a catalog definition, if nothing else, what is health insurance. Because if you're mandating an individual or an employer to provide it, you're going to have to tell them what it is. If you're subsidizing it through the tax code, you're going to have to make a definition. And so we're trying to reconcile many of the definitions of health insurance that currently exist and try to figure out which ones, if one or ones, it may be several at the time, should enjoy the advantage of a tax subsidy or should be able to meet the requirement of a mandate. The second one is insurance exchanges. Insurance exchanges are sort of consolidated purchasing marketplaces, venue, and you'll hear more about it later, but sort of allowing non-groups, lots of individuals, people with disabilities, people with special health care needs, those kinds of things, who are not currently able to purchase adequate health insurance in the individual market, to come together as a group in some fashion, as a sort of pseudo-group for purposes of health insurance, and to purchase group health insurance with all the advantages that grouping and cross-subsidizing offers. But the real legal question is, how do you do that through law, and at what level of government do you do it through law? Is it something, and there are a variety of proposals out there, at the federal or state level, is it something that can actually be carried out privately? Should it be a marketplace? Should it be something that the government constructs? Those kinds of questions. Privacy and security. Now, there are lots, as any health provider would tell you at this point, there are lots of different state and federal laws about privacy of individual health data and security to protect that privacy. They are of uneven application and in many cases actually contradict each other about what people need to do to protect this information and not circulate it widely. In addition to that, there are widespread activities going on now to improve or expand the use of health information technology, and both the McCain and the Obama plan predicate many of their financing schemes on the ability to be able to raise money by improving efficiency through health information technology. All of those health information technologies, however, exacerbate, or, well, I shouldn't say exacerbate, increase the importance of being able to solve the privacy and security questions and the multiple conflicting different ways of dealing with it. Purchase of insurance across state lines. Mr. McCain's proposal, and I would remind people that Mr. McCain will remain a senator, even if he is not the president, and that there were other people who support the proposal besides simply Mr. McCain. His proposal is to allow citizens of one state to purchase insurance in another state and thus effectively to bypass the regulation of their home state on what is a minimum insurance policy in order to go to a place, presumably, where there is less regulation on the policy. This actually, in addition to a lot of different economic and policy issues, poses some fairly fundamental legal questions about whether this can be accomplished by the federal government. Can the federal government force states to open up their marketplaces? Can the federal government force states to carry out certification for non-state citizens? Is there such a thing, and this is Jack Ebler's favorite, this commandeering state governments in order to force them to provide a service for the federal government? Individual mandates. Mr. Obama's proposal includes, among many other things, and Mrs. Clinton's proposal as well, a proposal to require that individuals purchase health insurance if they're not, if it's not, well, a requirement that individuals purchase health insurance. Let's just leave it there. I think ends with children. Mrs. Clinton's proposal was for everyone. But whatever the proposal, the question at hand is, can the federal government force individuals to purchase a product? It seems, and we'll hear more about this in a minute too, but it seems almost without precedent for the federal government to force people to purchase an individual thing and not get something in return. A requirement to purchase auto insurance is a condition of getting the driver's license. A requirement to purchase liability insurance may be a requirement for getting a loan or something like that. Requiring people to purchase insurance and getting nothing back from the federal government is an interesting question of whether the federal government, especially without a general police power at the federal level. Insurance discrimination on the basis of health status. Individuals who have ongoing health needs, genetic predilection toward disease, already diagnosed disease, disability, and chronic illness, may, in the individual health insurance marketplace especially, will, I shouldn't say may, but will encounter some form of, depending on whose shoes you're standing in, individual underwriting and price setting, or discrimination, because that is in fact what the individual marketplace is in the business of doing, is discriminating between high-priced patients and low-priced patients. they're going to experience some form of discrimination when they go out to buy things in the individual marketplace. And various plans rely on the individual market more than others. There are federal laws now about that, but for the most part, those laws are about group health insurance and don't have much to say about individual health insurance markets. But there are some interesting questions about the Americans with Disabilities Act, about the newly passed Genetic Non-Discrimination Act, and even some of the more arcane administrative acts about whether these general laws about discrimination on the basis of a status are in fact applicable to health insurance and whether they should be used to deal with the individual market. In addition to that, both the Obama and the McCain plans have various ideas about how to pool risks for such people if they can't get insurance through the individual marketplace. ERISA. Nobody's going to be able to deal with health insurance without dealing with ERISA at this point. But the most interesting legal question is the ERISA statute generally, and that's the magic of ERISA for purposes of the ERISA employers, generally preempts state regulation of insurance. So to the extent that the states have minimum benefit coverage requirements or those kinds of things, ERISA at the federal level preempts the state regulation of it. That in turn works as a very striking limitation on states' abilities to experiment with providing comprehensive health insurance, universal health insurance. Obviously, the Massachusetts model stands out as one, but some of the discussions that have been going on are the ongoing phrase of using states as the laboratory of democracy. Let's let states decide how best to how best to extend insurance to everyone. And ERISA stands as a legal, statutory, not constitutional, of course, but statutory barrier to doing so. And how could one work in or around the ERISA statute? Accomplishing these things through the tax code. There is a discussion both for jurisdictional reasons on Capitol Hill and also for a variety of political reasons of thinking about thinking about health insurance, about dealing with most of these proposals through the tax code, through subsidies, through penalties, through definitions. Are there concerns about this? First of all, are there constitutional concerns about varying tax benefits? And I think we've pretty much decided that there were not constitutional tax barriers here. But in addition to their administrative and implementation problems in putting the IRS, which has no particular expertise in healthcare, in charge of many of these activities. And there are some tax people who know way more about tax than I do who are exploring some of these. Finally, as the ninth of the 9+1, there's the question of executive authority, which is, of course, the gorilla in the what is it now, the gorilla in the middle of the room, the elephant in the middle of the room? What can the administration, the new administration, accomplish? Pardon? The gorilla's in a corner, the elephant's in the middle of the room. Okay. The 2,000-pound gorilla, that's what I'm looking for. What can the new administration accomplish without actually going to Congress and getting statutory change? And there are a variety of different ways one can look at, first, sub-regulatory kinds of things like director letters or interpretations that have been in Medicaid manuals or something like that can the new administration accomplish without going to the Hill at all. Regulatory guidance, and I don't know if people saw, but there was a long article in the Post earlier this week or at the end of last week about some of the last-minute regulations that the Bush administration is trying to get into place. Now the question is, can the new administration immediately reverse some of these or not? And then finally, there's some questions about executive orders and those kinds of activities or individual adjudication that the executive branch can accomplish without going to the Hill. There will be, I think, great interest in this last paper on executive authority because it is, of course, the way to accomplish things most quickly without having to experience the immediate politics of trying to move something through House and Senate. In addition to these 9 issues, the reason we keep saying 9+1 is there's going to be an opening framing chapter as well as percolated all through these 9 topics. Discussion about preemption, because there's going to be a back and forth of federal versus state all the way through these discussions. ERISA is only, and buying insurance across state lines is one example, but there are also questions of when discrimination laws start kicking in and those kinds of things. So a preemption discussion and the legalities and constitutionality discussions about preemption needs to percolate through this. Jurisdiction, and by that I understand it to be both congressional jurisdiction, a discussion of who's in charge here, as well as administrative agency jurisdiction, the people who are currently working on, for example, the Department of Labor and ERISA or HHS and Medicare and Medicaid. And then finally, discussions of how can we remedy some of these things, what remedies are provided for some of these activities, be they going to court, be they administrative tribunals, be they changing regulations, or having to go to the Congress. Those are the top 9 legal issues that we identified after consultation, plus the one percolating throughout. And after the break, I'll be glad to take any questions, and I think the rest of us will too. John, did you?
Well, I was going to invite Sheila a couple words. Jack and Sheila are both distinguished, but we asked them to participate, as they have been actively in this project, for 2 reasons. One is they're incredibly knowledgeable about all the issues that we're looking at. But secondly, as non-attorneys who've worked on these issues but have worked with lawyers through these kinds of issues, they've been incredibly valuable in helping us think about our end product. Because at the end of the day, what we want is an analysis that's useful not only to other attorneys steeped in this area, but also to people who need to make policy decisions. So I don't know if she has words about framing. Oh my God! This is a bigger here.
We were just trying to figure out what you were saying was we were kind of responsible for the dumb people. Sort of non-lawyer crowd. Alphonse? Yes. I think Jack and I will approach this from 2 different perspectives. Senate staff. And most of that with the Senate Finance Committee, the other half of that in the Office of the Senate Majority Leader. And so as I approached this project, I thought about it in the context of the audience, how the products would be used, by whom they would be used, what would the relevance be to the sort of day-to-day operations of the institution. Jack, I think, will also approach it from the perspective of an administration and how an administration would look at this. But very briefly, I mean, the relevance of the project, I think, is quite straightforward. I mean, we've had an election. We had the election yesterday. You have a transition that is about to occur that will bring into place an enormous number of people, some of whom, a very limited number of whom, will have had direct experience with the content about which we are concerned. But a large majority will not have had that experience, and say they are coming in as something as a blank slate in terms of trying to gather up information in the most productive way to try and begin a process relatively quickly as they come into administration. So the relevance is, 1, you have a new election, 2, you have a whole host of new people coming in. You also have folks who have been there for a very long period of time, who have gone through this, as many of us did, in the last go-around in 93, 94, and many of the questions that we are trying to sort out were questions that were asked at the time and were not fully answered. And so the project, which allows us to delve into the content around the questions that Tim just walked through, will be relevant to the discussions that many of us have had but have not yet concluded, and will help inform those conversations. Which brings to mind the question of who the audience is for this project. I obviously think about it in the context of the Hill, but there are really multiple audiences, and one of the challenges here is to essentially prepare a product that can be used by multiple audiences, some of whom will be lawyers from that perspective, many of whom will not be. Some of whom will be in the congressional offices, some of whom will be in the White House or in the agencies, some of whom will be stakeholders. So that you see in the makeup of these groups that kind of a representation, recognizing that the audience will be quite diverse in terms of their background knowledge, in terms of the skill set that they bring to the table, and their understanding of some of these fundamental issues. So one of the challenges is making sure the product is one that can be used by multiple audiences. And I think that's what John was gently trying to suggest, is that Jack and I are sort of the screen through which the project is coming to screen for that audience. That is the non-lawyer audience that will, in fact, be engaged in these issues. The other interesting question, I think, as we go forward, is the question of where the focus will be in terms of the production of a proposal. And there is an experience coming out of 93, 94 that would suggest that the bulk of the work on the details should occur on the Hill rather than at the White House level. There were lots of criticisms during the 93-94 debate that, in fact, House, by presenting a fait accompli, essentially a 1,300-page bill, precluded the body, that is the legislative body, from participating in that process, and as a result failed to get buy-in, failed to essentially get stakeholders at the table who bought in along the way in navigating some of the issues that had to be dealt with, some as simple as jurisdiction, which Tim has raised, that is which of the committees will be prominent in terms of trying to resolve these issues. You will get very different results depending on which of the committees are involved. My guess is, in retrospect, had the Clinton administration thought about it, going before Senator Kennedy perhaps might have been a more useful exercise than coming before the Senate Finance Committee and Senator Moynihan and Dole and others. So those kinds of questions, that is, where in fact some of these details will be decided, will in fact also be this question. So we really have to anticipate both a White House audience, administrative audience, Hill audience, with, I think, some of us hoping that, in fact, the details will be sorted out by the Hill, but the framework will, in fact, be set by the White House. They have to be the bully pulpit. They have to essentially frame the degree to which we are looking at reform, how extensive it's going to be, the time frame in which it occurs, but then essentially leave the details to the Hill. So the products we're looking at are attempting to try and deal with all of those constituencies. And then finally, before turning it over to Jack, I think of these papers as tools. The questions that Tim ran through are very real questions in terms of how you draft, what the implementation will be, at what level it occurs. There is this sense of the states are sort of laboratories. There are things that can occur, Massachusetts being a good example, that can occur there that cannot have occurred at the federal level or not easily have occurred at the federal level. The stakeholder groups are somewhat different. The history is somewhat different. Massachusetts already had in place a variety of insurance regulations, guarantee issue, and a number of other things that allowed them to buy business in and the industry in much more easily at that level. They had an individual mandate, so the pools were much bigger. So all of those questions essentially will influence how these papers are looked at as well. You can't look at any one of them individually. They have to be looked at as a set because all of those issues will in fact depend upon another issue in getting resolved. How you deal with questions of preemption, how you deal with questions of individual mandate, whether you use the tax code or not. All of those things will depend in part on the answer to the other questions. So as we look at this set, we look at them individually because they are individual questions, but they are a collective answer to a much broader set of questions. And so you really need to look across the full array of the issues that have been raised. But I think, again, the timing is spectacular. I think the need will be critical, and I think the audience will be quite receptive when, in fact, we produce these papers. Jack? Which is in December, we're told.
Second half of Legal Issues for Dummies presentation. I'm very proud that I can now use the takings clause in a sentence, which really kind of gets you a long way in cocktail parties. Just quick things, not much to say, because Sheila's so good at this. On the audience side, both within the executive and the legislative branch, you have different flavors of people. You're going to have policy people. You're going to have the classic general counsel's office, and you're going to have drafters, and they all have different needs. And again, part of the issue with these papers is being rigorous and credible within the legal community and understandable at least enough to the policy community that they can get it and then pass it on. Second thing I would say about the papers, I mean, and this may understate it a little bit. These papers will not be definitive. These, you got to think of these as a front end bit of staff work, jump starting the process for folks. They're going to be racing next several days to form transition teams and starting doing work. Congressional staff starting to do the work. The real government when it comes into place in January, and the permanent government was always there. I don't think any of us expect that this paper is that's done. But it is really intended to really help these folks think this through. They're going to have to turn to their own counsel to do this, but it's really getting a jump start on that seeding process for these audiences. The only other audience I would mention is there are sort of opinion leaders in the policy community and in the legal community that, again, you want to sort of seed this work with, and you want them to think of Georgetown and the ONeill Institute as a place to help get this started. So I think you're aiming there. So to mention this, and it really gets back to Jackie's presentation. So that, and I think it's important for those of you who are law students here to be thinking about what you end up doing in these things. Again, this is a situation where the policy person says, the best answer since sliced bread is an individual mandate or an insurance exchange. I want to do that. And now the question is, what are the constraints, which is of a legal paper. But then, again, as both Jackie and Tim said, that's really nice to hear about the constraints. I mentioned that I really, really want to do that. And by the way, there was just this cool little election, and I sort of think, that we should do that. So the question becomes, how can I do that? And part of the task here that you got to think about is often politely helping that person reframe the question and understanding what they're really trying to accomplish. And you may need to be able to say, well, you might have to kind of think of it this way rather than that way. But getting to that how is important. And then I think also you sort of, again, as you think of these things through, and again, sort of thinking of the kind of questions that you end up with here, what do you do in this situation where you really can't do that? And a very powerful person who happens to be your boss or an elected leader or a United States senator, how do you say, well, geez, I mean, we've looked at it every way since Sunday. We've consulted the best legal minds in the country, and Madam Secretary, we can't do it. I mean, we've all been in rooms where that's happened. But sort of how do you think about your role? And I think in particular making sure that sort of thinking through the situations where the policy sometimes turns to whether it's the legal community or the budget community and says, could you give me an excuse either for how to do this that I shouldn't be doing or how not to do it because I don't really want to do it. And you sort of think about your role in those situations. I guess what I push you for is to think about the role in the situation where it gets awkward. Because that's where it gets interesting. So I think that's sure.
Actually, one of the things that we think of, the other challenge I think here will be that these things may not all occur at once. And one of the issues that will arise is whether you put in place the tool that allows you to build on the elements over time. So, for example, if you arguably start in the middle. Well, what you start with is where has there been agreement in the past? Well, we know that fundamentally CHIP, Medicaid is an area of agreement. So let's say you start with those elements. All right, then what are the next pieces? Have you built a system that allows you to add on parts, mandates, tax subsidies, whatever it happens to be, and have them mesh together? So you can't assume that you're going to get everything done at once. So one of the challenges is things will occur over time. In place of infrastructure with these elements that allows you that flexibility going forward. And that is also sometimes the challenge. Because once you have set something in place, does it, have you precluded yourself from doing something else? Have you, suggested that you can't do tax fees for it, then questions about funding. So one of the challenges in the saying yes or saying no is anticipating that there are elements that timing will differ, and you have to build a system that allows you to build on those elements.
Yeah, and you'll when you read about this in the paper, there was a theory of health reform that says we have to do it all at once. You wrap it all in one big package, in which case you can answer the question in Section 482 by drafting a section over here that deals with it. Then, so that wasn't a real pretty picture when that was tried. Then, we're in this incremental world where you get into this situation, well, I could do this over here, but we haven't done that over here. You're now going to start reading about staging. It's sort of, it's not incremental, but it's a planned set of stages, and that's the kind of building blocks that I think you'll start getting to here. Yeah, staging. That means comprehensive, but we don't have the money. I kick it back to Tim or John.
comments, but they'll be involved in answering questions later. So I just want to be sure. Nora Connors, fellow with the ONeill Institute, and Sandy Hahn, who's a fellow with the Harrison Institute, but is also working full-time on this project. They're also helping supervise the production of the papers. And Elizabeth Sagani, who's our administrative support for the project. So all three of them have been involved, as you can imagine, in the process of getting these papers to where we need to be. But they're also going to be experts when we get to the substantive issues. So let me turn it back to Jackie, because I think we've got three presentations, and then we'll take a break after the student presentations.
And we have just very brief presentations to give you a sense of these papers. Our first presenter, and Marissa, you can come on forward. Marissa is going to talk to us about mandates to purchase health insurance, and then she'll be followed by Melanie to talk about insurance exchanges, and then Luis will wrap up by talking about executive authority. Each of the papers are in different stages of drafting, and they're going to highlight for you some of the key issues that are being talked about and really the legal relevance of those in a brief presentation for you.
My name is Marissa Hornsby, and I'm a student policy analyst at the Harrison Institute. And I'm just going to briefly talk about the constitutionality of health insurance mandates. And a health insurance mandate is basically what it sounds like. It's a requirement for by the federal or state government for individuals to from a private party or for insurers to provide health insurance for their employees. And this is a really important issue right now because a lot of health reform proposals do include a mandate component, such as the Massachusetts plan or Obama's plan, which includes an employer mandate as well as individual mandates for children. A direct and unconditional mandate for individuals to purchase to transfer money to a private party is unprecedented. And Professor Westmoreland spoke a little bit about car insurance, and that's a similar analogy, but it's not close enough to really to have the same legal analysis. So this is really something new, and there are a lot of novel legal issues that we need to consider. So first I'm going to talk about whether Congress has the power to legislate an insurance mandate, and then I'm going to talk a little bit about potential individual rights challenges under the First and Fifth Amendments. So there are two constitutional provisions that might allow Congress to legislate a health insurance mandate. First, the Commerce Clause, which gives Congress the power to regulate interstate commerce, and that includes local matters that substantially affect interstate commerce. And it's pretty well settled that health care and health insurance affect interstate commerce, and I think it's pretty well understood that Congress could use its Commerce Clause power to legislate a health insurance mandate. Congress also has taxing and spending power, and Congress's power to tax is quite broad, and the constitutionality of a tax will be presumed unless it burdens a fundamental right. And there's no fundamental right to be uninsured, so Congress could use such as in a pay-or-play model where Congress would tax individuals that were uninsured or provide tax benefits to those that do purchase insurance. Congress also has spending power, and it can use this power to induce state action. And one commonly cited example of this is when Congress withheld federal highway funds from states that did not raise their legal drinking age to 21. And something similar could be used here where Congress could withhold Medicaid or public health funding for states that did not implement insurance mandates. So Congress could use its Commerce Clause power or its taxing and spending power to legislate health insurance mandates, but the powers might be limited to some extent by federalism. The principle of anti-commandeering means that the federal government cannot command states to implement federal laws or policies that interfere with state sovereignty. So a federal mandate wouldn't require a commandeering element because it's a federal plan and Congress could preempt state insurance laws. However, if Congress wanted to rely on the states to implement insurance mandates, it would have to find a way around commandeering, and it would have to induce states to act without commandeering them. So one way Congress could do this is through conditional spending, conditioning federal funds on state compliance, or it could use conditional preemption, which would allow states to opt out of federal preemption and direct regulation if they comply. So because Congress can sort of get around these commandeering issues, federalism challenges are unlikely to be successful. There could be individual rights challenges under the First or Fifth Amendments, and the Fourth Amendment incorporates these amendments, so this analysis applies to both federal and state legislation. A challenge under the First Amendment free exercise clause could be raised based on a religious objection to even having insurance at all. But as long as the law is generally applicable and there's a rational basis for applying it to both religious and non-religious practices, the law is likely to be upheld. Now, because of incorporation, free exercise applies to both state and federal legislation. However, there's a federal law applying only to federal legislation, which also relates to the free exercise of religion, and that's the Religious Freedom Restoration Act of 1993. And that act requires that in order to burden the exercise of religion, the federal government must show a compelling interest with regard to the particular claimant. So that's a higher standard than the rational basis test under the free exercise clause. So it's possible that a health insurance mandate might not meet that higher standard. So a federal mandate would need to include either a statement that the Religious Freedom Restoration Act does not apply or a religious exemption. There are potential challenges also under the Fifth Amendment due process and takings clauses. A substantive due process challenge is unlikely to be successful. General economic and social rights are generally upheld as long as there's a rational basis for the law. And it's different in the case of fundamental rights, but like I said before, there's no fundamental right to be uninsured. So a health insurance mandate would be a rational basis test. It's unlikely that a takings challenge would be successful as well. There's no clearly analogous precedent in this area, so there's a couple outlying questions. First, is money considered property? And there's only a couple of Supreme Court cases that have dealt with money as property in the takings context. So it's not exactly clear where the court stands, but it seems pretty likely that money would not be considered property for these purposes. Additionally, one question is whether compulsory purchase of insurance would be considered a taking, and it probably isn't. If it were, it would be a regulatory taking, where the government regulates the use of the asset but doesn't actually use it itself. And compulsory insurance purchases are very much unlike any other situation in which the court has found a regulatory taking. So in conclusion, Congress has the power to legislate a health insurance mandate under the Commerce Clause or its taxing and spending powers. And challenge Fifth Amendment or likely to be successful. So it seems pretty clear that a health insurance mandate would be considered constitutional. And if anyone has any questions, feel free to ask.
Thank you very much. Nice job. Very nice. We're going to try to get them all in, and then we'll have all of our questions all together. I'm sorry. Take a little break, and then we'll go to questions. And I forgot to mention, these slides are also posted for the students on courseware, so you can access them, and we have some hard copies for handouts also, so we should get those around.
No problem. Well, my name is Melanie McLean, and I am also a student healthcare policy analyst with the Harrison Institute, and I have been tasked with researching health insurance exchanges. And when I first was tasked with this project, I started by looking at the way in which those who are insured go about gaining coverage. And what I found was that many are covered through group plans where an entity that connects them all, usually their employer, negotiates on their behalf with insurance companies. And a health insurance exchange would act in a very similar manner. It would act as, in the same way a benefits organization does in a Fortune 500 company, linking together individuals who now are uninsured, either because they are with a small business that or because they're an individual, and negotiate on their behalf with insurance companies. Health insurance exchanges, also called alliances or connectors or cooperatives, actually have quite a bit of bipartisan support, and they were a large component of President-elect Barack Obama's health care reform plans. It's really seen as an opportunity for all of the different members who are playing in the health insurance reform field, whether it be uninsured individuals who would have access to health care in a more affordable way, or insurance providers who would now have the market organized in a new way. Additionally, it's also seen as a wonderful tool for being able to implement other different solutions within the healthcare arena, within the healthcare reform arena, whether it be individual mandates or tax credits, because of the way it organizes this particular market. Now, there are two components for implementation of health insurance exchanges. There is a design strategy component and a legal component, and the two are interconnected in that the design, the way in which you go about designing a health insurance exchange, can cure some of the potential legal issues, and the legal issues that arise can also be cured with strong design and oversight. And the three frameworks I'm going to discuss with you today are a federal exchange, a state exchange, or a private sector exchange. And having been in your shoes, I'm not going to issues, the constitutional issues that Marissa already talked about under the federal and state exchange. So I'll just be raising new issues in addition to those, but I'd like you to keep those in mind. Now, under a federal exchange, in addition to the constitutional issues, there's also the issue of the Administrative Procedures Act, which governs and outlines the way federal entities go about managing their different projects and their programs. With the Administrative Procedures Act, it provides oversight, a line of sight for the public in understanding the adjudication process, rulemaking, and freedom of information. However, when dealing with health insurance information, it's something that should be considered in designing a federal exchange. However, it would not be a barrier to implementation. Now, looking at a state exchange, it also goes back to the role of the federal government and the relationship between the federal government and state governments. There is federal legislation right now that preempts the states from doing anything that would touch upon or impact employer-sponsored health insurance. Now, because this health insurance exchanges have bipartisan support, and both sides of the aisle have committed to allowing the states to really be incubators for new and creative solutions in healthcare reform, it's much more likely that this will not be an obstacle to implementation, but modifications may potentially need to be made. When looking at private exchanges, there are two new concerns that arise from a legal standpoint, one being antitrust. If a private entity were to organize an exchange and negotiate on behalf of the uninsured, it potentially, if the entity became so large that it was able to exert undue pressure on insurance companies such that it undermined their profitability, then there would be an antitrust issue. In reading this, I thought this was a little bit ironic in that the uninsured at times are somewhat of an overlooked population. And when you look at antitrust in this concept, it's almost flipping the script, and whereas they would have all of the power and the insurance companies would in effect be financially undermined. Now, there's also the issues of business torts and fiduciary duties. Right now, with the states and with the federal government, they are insulated from any type of tort or liability actions if those members of the exchange with some of the decisions that were made or feel as if the decisions were not made in the best interest of the members of the exchange. And so when looking at a private exchange, that could potentially be an issue. However, it could be cured with proper oversight as well as the states or the federal, well, I guess in this situation, the states indemnifying directors from liability. So now that you have a better understanding of the exchange, I just want to leave with you under this particular framework, health insurance right now offer a potential solution that can incorporate many aspects of healthcare reform, and there are no legal issues that would prevent us from being able to implement health insurance exchanges with proper oversight and proper design.
Hi, good afternoon. My name is Luis Rodriguez, and I'm a health policy analyst with the Harrison Institute, and I'm also a third-year law and public policy student here at Georgetown University. And today I'm going to be presenting about the President's power to reform health care. And to do this, I'm going to be using three policy proposals taken from the Obama and McCain health care plans. And those three policy proposals are expanding child coverage, reimporting prescription drugs, and reducing health care costs. And these three policy proposals correspond to three tools that presidents have to reform healthcare. And so now that Obama has been elected president, he's going to be confronted with the question of how can he implement the policy proposals he's made during his campaign. And so, for example, he's proposed a new national health care plan. He's proposed, well, he hasn't proposed, but McCain has proposed tax credits. There's also proposed a national health insurance exchange. And there's also proposed insurance mandates. And so Obama now is confronted with the question of how do I go about implementing these policy proposals? And to find the answer to that question, he has to start off by looking at the Constitution, because the Constitution tells us which branch of government can do what. And so the legislator and the executive have different powers. The legislator has the power to pass laws. The executive has the powers to execute or to implement laws that Congress has passed. And so thank you. So basically, under these powers that the president has under the Constitution, basically the president has two sources of power. One comes from power that Congress has delegated to the president in statutes. And the second source of power is the power that the president has through his own power found in the Constitution authority. And so the first source of power is going to be important when the president wants to govern the actions of administrative agencies through his control of the federal bureaucracy or the federal administrative state. And the second authority is important for when he wants to direct the actions of agencies and officials in these agencies. And so the president actually has a lot of power to reform healthcare without having Congress pass any laws. He has a wide variety of tools that he can use. And so today I'm going to be talking about the three top tools, but he has a lot of other tools that, for time reasons, we couldn't talk about today, but are also very important for any proposals that the next president has for reforming healthcare. And so I'm just going to begin by talking about the three specific policy proposals. And remember that these policy proposals come from both Obama and McCain. And this specific proposal about expanding child coverage actually comes from the Obama healthcare plan, and it is to expand the CHIP program. And the CHIP program is based on healthcare in low-income families. And so Obama's idea is to expand CHIP coverage to allow states to cover more low-income children. And to do this, what he's going to have to do is reverse what the CMS director submitted under the Bush administration that restricted the ability of states to cover low-income children. And so this letter is actually an example of sub-regulatory guidance. And what that is like letters to state health officials, or it's the actual policy manuals of the different federal and state programs. And so all that Obama has to do is simply have his CMS director write a letter saying that these changes will be repealed. And it's a very straightforward and easy solution. Another policy proposal, this is actually taken from the McCain health care plan, and it's to bring greater competition by allowing the reimportation of prescription drugs through Canada. And so Congress has already given the president the power to do this through the Medicare Modernization Act of 2003. The problem is that the Secretary of HHS hasn't issued any regulations to be able to do this yet. And so if this is something that the next president wants to do, he can simply ask the Secretary of HHS to initiate administrative rulemaking, which would allow the HHS to take these actions to allow the reimportation of prescription drugs, which will have the effect of being able to reduce the cost. And so finally, the last policy proposal that I'll be talking about today is a proposal found in both candidates' health care plans. And it is basically to develop best practices with respect to the operation of federal health care plans. And so for this, the president can issue an executive order based on his own executive authority found in the Constitution and basically direct the Office of Personnel Management, who has governance over the federal employees' health benefit plan, and just have them memorialize some best practices which can serve as guidelines for other federal health policies in terms of promoting best practices. And so in conclusion, today I've talked about three specific policy proposals on the left-hand side of this chart, which correspond to three presidential tools, which are sub-regulatory guidance, administrative rulemaking, and executive orders. And so when the president considers how to use which tool for what purpose, there's certain disadvantages and legal advantages. And these advantages and disadvantages come from the checks and balances that each branch imposes on the other. And so basically, for example, with expanding S-chip eligibility, the advantage of being able to do sub-regulatory guidance is the fact that something doesn't have to go through administrative rulemaking. Basically, the president can decide on a policy option and then implement it. He doesn't have to go through notice and comment rulemaking. So it's a very easy action to take. The only problem is that maybe someone's going to challenge the fact of whether it's guidance and whether it's in fact a rule. Because if it's a rule, it has to go through administrative rulemaking. There's more procedural hurdles that the policy has to overcome before it can take effect. Reimporting prescription drugs, that's through administrative rulemaking. And this basically allows an agency to take an action. And for this, it's actually really good because the courts actually give agencies a lot of deference. They give a lot of leeway for agencies. When Congress gets upset about that, it can actually take away the president's power to issue regulations or take certain actions. So that's the thing to be careful about. And then finally, for executive orders, this is basically the president's own constitutional authority found in the Constitution, and it's where the president can direct federal agencies to take some action. And so for here, he doesn't have to rely on any delegation of congressional authority to take action. The problem, or the concern here is that if Congress doesn't like the action the president takes, they can actually nullify a specific executive order, or it can legislate in contradiction to the area of law that the president is acting in. And so for all of these tools, we have to keep in mind that although the president can act at any time, Congress can overturn an action taken by the president, either by passing a law or by overriding a veto that the president takes in response to congressional action. So I just want to say in conclusion again that the president does have a lot of power. He has a lot of tools that he can use to reform health care, and that he just has to be mindful of the checks and balances that each branch is going to play when he decides to take action to reform health care.
Why don't we take a brief break? This has been a pretty long run here. So looking at this clock, we'll start promptly at 10 to 4 and then go to 4:30. And so why don't everybody take a little break, but we'll start up there. Questions, we'll start as always with Colloquium students first, and then we'll turn it to the audience. So thank you. What a great presentation. So thank you.
For your summary, so we can recognize that's what I mean is like you're answering the question. Like you were